All right, well, welcome back to the Real Estate Syndicator Live, episode 29. And today I've got a really special guest for me, my personal trust attorney, Kevin Day, the man himself, one of the foremost experts in asset protection, trust formations. And of course, we're going to talk a lot about the Delaware Statutory Trust, which at the end of the day is a trust. And so Kevin, I've known Kevin now for, I was actually doing the math, Kevin, early today. I know it's been since before I met Heidi. So it's got to be 10, 15 years now.
I'm thinking 15.
Yeah, it's been a while now. And, we've shared the stage quite a few times, and he literally lives down the street from me, which is always nice. And he is one of the partners at Trust Day and Associates, and they specialize in asset protection trust, sort of next level asset protection, and estate planning, which I want to get to today as well, because estate planning is definitely a major piece to the syndication puzzle for syndicators. And so I think everybody needs to have not only an asset protection plan, which we've talked about, but also an estate plan. But without further ado, welcome, Kevin. First, welcome to the community. Really appreciate you taking some time out of your, I know, busy schedule.
Absolutely. And you and I are family, so your people are family. So we'll take as long as they want.
I appreciate that, my friend. I appreciate that. So I want to start with this Delaware Statutory Trust, these DSTs, which should not be confused with the other DST that we often hear about, or sometimes hear about, which is the Deferred Sales Trust, which I don't really want to talk too much about. It's not really what we're talking about today, but it always comes up, the DST always comes up in the context of 1031 exchanges. Somebody wants to either accept an investor who's doing a 1031, or maybe they want to just accept money in 1031. And we typically do it through a tick structure. But tell us, Kevin, what exactly is a DST? What is a Delaware Statutory Trust, and why do people really care about it let's start with the 1031 context.
Yes. We're going to be, so the Delaware Statutory Trust is a descendant of the International Asset Protection Trust, where the first time in the US, you could set up a trust and name yourself as a beneficiary. They were used for lawsuit protection. And Delaware, being all business-minded, not only did the same Hague Convention kind of statutory provisions for lawsuit protection, but they expanded it for business purposes. So you make you're able to buy in a beneficial interest in the subject property. Now, they're different than REITs, real estate investment trusts, that have been around for a long time, that allowed the same kind of investment, but they're treated as corporations. So they're treated more like stock. And the REITs are kind of like mutual funds for real estate. So the big thing on Delaware Statutory Trust for 1031s is that there are always, instead of multiple properties, or a single property that somebody's that they're bringing up for investment. The thing is, unlike REITs, we have statutory certainty from 2004 that says that they are acceptable for 1031 exchanges.
So before we get into 1031 exchange, so usually when we do a syndication, we have a limited liability company, LLC. Sometimes we do LPs, but generally LLCs. We can do either one, where the investors tend to be limited partners, or really members of an LLC, and then the sponsor is sort of the manager of the LLC. Can you translate that into a trust? I mean, if I'm an investor who is investing in a syndication, I right now would own 1, 2, 5% of a LLC interest. When I'm buying a DST, a piece of a Delaware Statutory Trust, translate that for me. What am I getting as a passive investor when I'm investing in one of these DSTs?
Well, you can never be a manager. You can have, under IRS rules, you can have no control. So you don't have the option of shares that allow you to be, or an interest that allows you to be a general partner to get accelerated write-offs if you have a good year in your other income and want accelerated depreciation. They act similarly. There is protection that's going to be similar to a charging order, but both of them are tied to all the other investors, and it's not small enough group, so you're not really going to say have a withholding of distributions or anything like that in either one.
Yeah. So I'm going to get into a second. I want to do sort of the pros and cons of a DST for syndications, but before I get to that, the vernacular that I always hear about when you and I are doing whether it's our estate planning trust or asset protection trust, there's always sort of this trustee and beneficiary relationship, right? Somebody's the trustee who kind of runs the day-to-day, and then the rest of them are beneficiaries. Is that the same thing with the Delaware Statutory Trust in terms of as a passive investor? Am I becoming sort of a benefit? Because there's no ownership in a trust, right? The investor would just be a beneficial owner. Is that how it works?
It's exactly the same vernacular. And so there's a trustee, and the people that are investing are buying beneficial ownership, beneficial interests as beneficiaries. And
the way these guys, just as sort of a context too, I mean, the way that, and again, I'm not here to say whether you want to do a DST or not, but the way it typically would be structured is actually very similar. Think of it as, instead of having an LLC, you would create a Delaware Statutory Trust where your investors would be the beneficiaries of that trust, and you as the GP would be the trustee. I mean, really, or one of the trustees. So I believe one of the trustees has to be in Delaware, right? It has to be a Delaware trustee. Is that right, Kevin? Or
yes. There always has to be a resident using the LLC parlance manager, and that can be hired, but that's an additional expense.
Right. So just again, from a structural standpoint, just kind of keep it super high level and simple. If you're going to do a syndication with a DST, all you're doing is simply, instead of creating an LLC and an operating agreement like we typically would do in a syndication, you would go out there to a Delaware, have somebody like Kevin set up a Delaware Statutory Trust, create the trust documents, similar somewhat to an operating agreement, where again, investors are giving you, let's say $100,000. They're going to be a percentage, not owner, but beneficiary of the trust. And then you as the sponsor will be the trustee, and you sort of run the day-to-day. Is it just Delaware? I think I remember seeing something about are there other states? I think Wyoming has, it can be technically a Wyoming statutory trust, right?
Yes. So the first copycat of the Hague Convention, the International Asset Protection Trust, was Alaska. And now we have 15 or 16 states that have copied that. Wyoming, South Dakota, Nevada. There's only about 5 or 6 that are good for lawsuit protection, but all of the 16 that have the statutory states would work. Delaware has just been better at marketing them.
Got it. That's what. So it doesn't really okay
for 1031.
For 1031. So if somebody were to come to me and say, hey, you should really set up a Wyoming statutory trust or an Alaska statutory trust, for our purposes, all of those would work equally for the 1031?
They would.
Cool. All right. So let's talk about some of the pros. And I know I always focus on the cons, but there's a bunch of cons, but let's focus on the pros. Why would someone come to you to set up a Delaware statutory trust? Let's start with sort of the 1031 option, and then let's talk about also the asset protection. Why would I think about doing, as a syndicator, a Delaware statutory trust over just a regular LLC or an LP?
Really, it's having control, and there's a little bit of mystique about it, because people are, even if they haven't used LLCs, just by being in our society, they know how corporations and LLCs work. And so it's an advantage to the sponsor and a disadvantage to the investor, because you're using this mechanism that people aren't familiar with.
Yeah, and I have that as actually one of my cons in terms of all the same cons if you're an LP that you've got no control, there's no liquidity, it's a long-term investment, like all the traditional, I won't say negatives, but all the cons you can think of a regular syndication would apply to a DST, whether it's an LLC or anything like that. But let's talk about the 1031. So this is something relatively new, but I would think this is for syndicators, the number one pro of using a DST is to have that ability to accept 1031 investors, right?
Exactly. Yep.
This is relatively new because when I started doing this stuff, it didn't even exist, but I think it was 2004 that we got that IRS ruling. So that allows you then theoretically, if you are a investor who's got a 1030, who's got a piece of property, who's relinquishing a piece of property and looking to sort of 1031 into a syndication, well, if the syndicator sets up a DST, they could actually do that because it's considered a like-kind exchange, right?
Correct.
Right. Is there, and actually one of the pros I was thinking of, Kevin, before we came on is that, sometimes people do 1031s and forget about the syndication part, but they just want to do a 1031 and they've got remainder profits, right? So let's say they've got $1 million in equity that they want a 1031 and they find a property for 800 grand and they only use $800,000 of that. Well, that additional 200 grand, DST would be a nice little option for them to have to put that remaining, because otherwise you're going to get taxed on that remaining, 200 grand or something. So having the ability to find a syndicator that is using a DST is fairly good. Do you have a lot of clients who use it for 1031 purposes, or do you primarily have it for asset protection purposes on your end?
Primarily for lawsuit protection. Most syndicators that we've dealt with, like the TIC, like the LLC, they're familiar with them. They want to pay attention to the real estate versus these new terms, new procedures. They don't want to get caught up with anything out of left field, so they're using LLCs.
Cool. And I am seeing some people dropping comments in the chat. So if you've got a specific question, remember this is for you guys. So Julie, I see your question and I'll get to it in a second, but if anybody's got questions, please drop them in the chat. Anonymity, is that something that DST has some sort of superior power over LLCs, or is that one of the benefits?
They are not listed. That anonymity is a plus for the investor.
The investor. Cool. And then what about us lonely California investors who have to a lot of times deal with our California franchise tax, that gnarly $800, and other states like as well, like Florida, I think even Delaware itself has a franchise tax. Is this a way for investors to sort of get around that? Because that's another sort of rumor mill that goes around that if you set up a DST, then they're not taxed. They're not considered from a franchise tax perspective. You're not going to get nailed to that $800. Would you agree with that, or is that?
I would agree with that absolutely right now. Franchise tax board is nastier than the IRS. They'll try to figure a way around it. I still don't understand how they can tax rent on property outside of California, but that's their position, and there hasn't been a large enough lobby to contest it.
Right. Okay, so if I wrote down my pros, obviously the 1031, potentially the 1031, we're going to get to the limitations in a second, but 1031 is probably the first pro, a great option, I think, for limited partners who got some remainder from a 1031. You've got some excess funds that you need to place somewhere. That might be a good option. Asset protection. If something were to happen to the property, if somebody slipped and fell, obviously the DST would be legally responsible, but because everybody's passive, they wouldn't be able to theoretically anyway pierce the corporate veil. So that's number 3. Anonymity, and so not subject to California. You think right now? I wonder why everybody does. Should everybody in California? I mean, you and I haven't set up a DST. Should I go run out and set up a DST then? Because I'm here in California. If I've got I guess I don't have 1,000 little rental properties that would get taxed at $800, but do you recommend, if you're in California, to seriously consider it sort of for an asset protection perspective?
Absolutely. And I would use that kind of in place of a holding company. It's a surrogate for the individual. And that's one more argument that it shouldn't be taxed here in California.
Before I get to the cons, I wanted to get some of these questions that are asking about actually, you know what? I am going to go through the cons because Julie, you had a question about the lender appetite on TIC versus DSTs. What are the pros and cons of lender appetite? Which one has the best lending availability? You want to take a crack at that? I've got a thought on that in general, but do you see any issues with lenders who, is it just either they're unaware of what DSTs are and it doesn't check the box at all?
Financing has a preponderance of misunderstanding about trusts, and it goes back to the traditional trusts that we only had before the Hague Convention on trusts that we were signatories to. The only way they had a irrevocable trust was for the original owner, the person with all the wealth, setting up a trust for their children and grandchildren and naming the trust department of Bank of New York as the trustee. And so when these new trusts, the Hague Convention trusts, came out where they were the original owner is the settlor and the first beneficiary, tax-wise, it's very clear. Everything that's signed and everything says that it's for tax purposes, it's still me. It's just not me for ownership purposes for litigation. And the two laws are very distinct. Well, banking just hasn't gotten into that. You can get up into upper management, but your normal lender that you're going in and seeing on the ground floor just doesn't like trust. And that's why even with revocable living trusts, very clear that it's not irrevocable. There's no lawsuit protection. They still, well, until recently, made you take it out of the living trust just in case it might be deemed an irrevocable trust by a court. And so they just don't like trusts, and you have to get up into upper management and, you know.
It's like one of those catch-22s. It's like, well, hopefully everyone's got some sort of an asset protection plan, but the whole idea is to make it look to the world anywhere, a potential creditor, that you've got no funds, nothing's in your personal name, everything's kind of in a holding company or an LLC or an asset protection trust or wherever you put it. Well, that's great, but when you're trying to show the bank that you've got all this liquidity and all this cash, it becomes that sort of that catch-22. But let me go through, because Julie, this comes up in a different, which I think will be interesting for you in terms of the lender appetite, because I came across this article. Kevin and I were talking about it before we came on, about sort of the limitations of the Delaware Statutory Trust. And this guy, I want to give him credit because I'm kind of basically plagiarizing from him. So his name is David Wieland. And he wrote something I thought was cool. It was the 7 deadly sins of the Delaware Statutory Trust. But as I was reading through this, it just became super clear to me why DST just has a lot of limitations. So I wanted to make sure the community was aware of these limitations. And Julie, lending is one of them. But Kevin, let's go through these. I don't know if I want to go through all 7, because I don't think all of them are necessarily perfectly related to syndications. But the first limitation is you can't, once the offering closes, you cannot obtain additional capital from your investors or even put in additional capital to yourselves. And you were saying something super interesting before we came on, Kevin, that because of that, a lot of the deals end up having a ton of leverage on them because they've got to raise additional capital just in case, something happens in terms of, hey, I suddenly need a new roof or I need something. And where we ordinarily do a cash call on a regular syndication, you wouldn't be able to do that with a DST.
Yeah, if you look at all the critiques of them, or I guess all the red flags to examine a 1031 into a DST, or any investment into a DST, is to look at the underlying investment itself. And often they're over leveraged, and it's for that very reason. They're not the normal deal for the same type of property in the same area. They're usually over leveraged compared to something similar.
Yeah, I mean, just think of it. You're raising capital for a project. You're buying a 100-unit apartment building, and you've got to make sure you've got enough capital that you never have to do a cash call. It's almost like cash calls. Not only a cash call is not allowed, you can't even put in your own money. Like a lot of times syndicates say, well, hey, if the roof happens or if occupancy goes down or whatever, I can put in some of my own money. But I think that's a huge a huge deadly sin, I guess, one of the drawbacks. And this is, by the way, this is very similar. When we did the episode of 1031 exchange, I think it was episode 4 or 5, we went through those 15 limitations that the IRS has when you do 1031s into a syndication, even though we can do it. This is something similar, guys. This is like the 6 or 7 things that you cannot do or limits from a DST, which really is what makes it sort of challenging. This is the big one for me, Julie, and this applies to sort of your lender. And not only can you not get additional capital from your investors or yourself, according to this article, Kevin, I want to make sure you agree with it. You cannot refinance or get additional loans. You cannot get a supplemental loan or refinance a loan. Once again, once the loan's in place, once the DST is in place, once the offering closes, that's it. That's it.
I don't have certainty, but I've heard that several times, and it's not a policy of the banks or financing. I think it's an IRS limitation.
Yeah, no, I agree. These are all, it's like the same thing with the take. People come and say, hey, can we do this? I want to do a 1031. Can I do this? Can I do that? Can I structure it this way? And I always say, look, from my perspective, from the SEC's perspective, no problem. We can do what basically, we can do whatever we want as long as we're disclosing it. But the IRS typically will have some issues because, again, we're talking about 1031. So the IRS wants to make sure this doesn't get abused and this doesn't get used, because at the end of the day, it really isn't. It's not really like kind exchange, right? You're literally going from a property into as a beneficiaries of a trust. So anyways, that was the other one that I thought was interesting. The other one I thought was a killer for most of us. I mean, most of my clients, Kevin, are doing sort of major value add deals, right? They're buying something that's undervalued primarily because it needs a lot of work. So they'll raise additional capital, they'll fix it up, and then they'll start getting to work to raise the rents and raise the occupancy. But if I was reading the IRS code, the IRS revenue procedure, you can't do major value adds or rehabs. You have to, because you're sort of limited to sort of minor. Let me read the exact terminology here. You're limited to doing normal repair and maintenance and minor non-structural capital improvements. So if you're looking to do a major value add, it doesn't look like you could do one through a DST. You'd have to buy something that's already cash flowing that doesn't need any additional work,
right? Which is not not in the spirit of this tribe.
Right, exactly. And then the last one I'll do, because I think the other ones aren't necessarily super relative, is that, and there's a workaround about this one, but you cannot you can't actually renegotiate leases like with your tenants. Right, you can't either renew leases or do new leases. Now there's a workaround because you end up hiring another company to handle that all for you, almost like a property manager, and you enter into one lease, which is the master lease, and then they do all the subs. But this just kind of goes to this whole issue of it just being really complicated. Try to explain this to your investors when they're looking to write you a $50,000 or $100,000 check that, yeah, you can 1031 in here, but because we have some 1031 investors, we're setting this up as a DST, and therefore we can't do certain things. I think this is probably the main reason that, well, we certainly don't do them, but that's why I think the DSTs aren't necessarily, from a syndication standpoint, super popular. So Julia, I wanted to get to that before I went on the questions. I know you were concerned about the lender appetite, and did that answer your question, Julie? If you're on? Well, I'm going to assume it did. Cameron asked, can you explain the lawsuit protection scenario under a DST, Kevin?
Oh, from a 1031 invest?
Just from a lawsuit protection standpoint. I think let's assume we're not doing a 1031. How am I, if I buy a piece of property and have title in a DST as opposed to an LLC, for example, what do those scenarios look like? Where are the pros or where are the cons?
Yeah, a trust is a separate legal owner. It's an ultimate owner, where corporations, LLCs, limited partnerships are separate legal people from us, but they have to have an owner. They're not an ultimate owner. They have to have a shareholder, a member, a partner. And so theoretically, a corporation could be owned by a LP that's owned by an LLC that's owned by a corp. It won't end until it hits one of two entities. A flesh and blood human, you're an ultimate owner, nobody owns you, and nobody owns an irrevocable trust. It's a standalone owner. And there's several reasons why irrevocable trusts are lawsuit proof. And one of them is that concept that they aren't you, even though you might have set it up you're a primary beneficiary in it. You can still manage underlying companies, but as long as you're not the trustee, it's not you and can't be taken.
Is a DST considered irrevocable? Is that irrevocable once you set it up?
It is considered irrevocable.
Okay. And you get the asset. So if you buy a property in a DST, somebody slips and falls, you as the beneficiary, so not really the owner because there are no, but you have no liability issues, right?
You don't. So like a limited liability company, you're only limited to your investment.
And what about the flip side? Do I get the charging? Do I get sort of the equivalent of a charging order protection if I ran over little old lady, crossing the street and I get sued? If Kevin Day got personally sued for $1 million, can they go after your DST interest?
No. So it is effective if it's a more nuclear. You're setting up the DST for any statutory trust for yourself and your family to hold crypto or to hold your real property away from your personal liability. But just like a broader investment LLC, it's not closed enough to be able to restrict. You have the charging order or equivalent with the trust as you do with an LLC. But just like any broader investment, you're investing, if all of us on this screen, we're all investors, I'm not going to say, hey, don't give me the payout because I want to use it for vacation or my children's, education. And once you make one distribution, you have to distribute it to everybody.
Yeah, that's a good point. I always forget that part where if it's just you, if you're the sole owner or it's your husband and wife, or maybe it's just one partner, you guys can negotiate. If I get sued, let's stop making distributions. But if you're in a syndication and one of your limited partners that owns 2.5%, gets into a car accident and there's some kind of a charging order, you're going to provide the distribution anyway, because obviously you're not going to hold up that distribution to everybody else. And it's that distribution that then can get diverted to pay off your whatever your debt is to the creditor. So
yeah, you in a tribe like this, you do have a little bit of flexibility because you could make an offering to roll over. So let's say I had the judgment against me and the investment is not only at the payout at some end on sale, but also we're getting income stream. So you couldn't withhold the income stream. So there's going to be a lien against that I have to pay all of it or a portion of it to the court, to the marshal to satisfy my judgment. But as a team or an option that the manager, the sponsor could do is say, hey, there's a rollover opportunity that not everybody's going to take into this next, so it stays in the structure. And, a lot of people are going to, hey, I've got plenty of other income. So if 80% stay in, certainly the person with the judgment is going to say, keep me in. Right. So there's a little bit of a potential workaround, but it's not going to be guaranteed.
If you don't mind me asking, Susan, well, it's actually Susan that's asking, what does something like this cost if you're setting up a DST? And does it matter whether you're setting it up just for yourself or sort of asset protection as sort of as a equivalent of a holding company, or whether I'm doing it as a syndication? What's the cost of setting one of these up, ballpark?
They're both the same. They're $14,000.
There's a cost issue right there. Tim asked, can you maybe walk through an example? He says, sell a property in 1031 into a syndication and have the remainder go into a DSTB, a Delaware Statutory Trust. I mentioned that one, Tim. I mean, what I was alluding to there is, let's say I have a property that I'm trying to sell in 1031, and let's say it's just property, like in your example, it's property A, and I found a replacement property. I'm selling my property and I'm buying another property down the street, completely unrelated to syndication. I may not use all my proceeds. I may have $1 million in equity that I have to, the profit that I'm looking to put into another property. Most of the time you use it all, and sometimes most of the time you actually put more money in to go buy a bigger property. But sometimes you may be you're downsizing, and so maybe I got $1 million in profit that I'm looking to 1031. The new property I'm only using 800,000. Well, now I'm left with $200,000. I think the term for that is boot, meaning I'm going to have to pay taxes on that additional 200,000 if I don't use it. Well, hey, if I find a syndication that has a DST structure, I could become a limited partner and write a $200,000 check and become a 2, 3, 4% owner in quotation mark to that syndication. That was kind of the example that I was thinking of as a potential benefit for an LP, because it is such a, it's really quick to identify, right? You don't have to go looking for actual properties. You literally can talk to a couple of sponsors. But again, I don't know too many sponsors that are using DSTs, and I think this is you're finding out right now why the cost and all the sort of limitations that syndicators have to go through. It just doesn't necessarily make a ton of sense. Julie, no capital calls then, yeah. So no cash calls. No, you can't even put your own money in. So once it closes, it's irrevocable, right? So it's irrevocable from an asset protection standpoint where you can't change it. But the IRS specifically doesn't want you to be. So yeah, reserves. So Julie says reserves 100%. So you've got to either overraise. So you got a bunch of reserves that are just sitting there. And as Kevin mentioned, you got that's why a lot of these deals are highly leveraged, because you need to have that extra money sitting around. But Julie, there's no assurances that the reserves, how much are you going to set aside for reserves? And what if there's like a major repair, or like a roof or something, or maybe there's a great financial crisis 2.0 when your occupancy goes down to 50% and there's not enough money. Those are all major issues. Kevin, Alex asked, can you provide info on deferred tax trust? Is that different from a deferred sales? Well, deferred tax trust, is that the correct term?
I'm not familiar with that. Certainly the statutory trust that we've been talking about defers your tax in the exchange. So Alex, do you have a little bit more info?
Yeah, I think it's just the other definition. I think it's technically, it's also called a DST. It's a deferred sales trust. Mm-hmm. Is that what you're talking about, Alex?
I wasn't sure. Somebody told me about it today, and I was trying to see if it was the same thing. I was thinking it was maybe the same thing as a DST, but they said they didn't think so. So I saw your email today. I jumped on it. I wanted to kind of see if there was a difference or if it was the same. I never.
Well, I think we're talking about I think we're talking about the same thing, and we're talking about a trust that's been around for many centuries. Really, trusts have been around for a while, but as of 2004. These trusts have now been recognized as like-kind exchanges, so that you can actually 1031, which is really a deferring of your taxes until you actually end up selling when the DST ends up selling that property. Julie, I knew Julie had a ton of questions because we talked about it last week. Kevin, Julie says, I had read that TICs were getting difficult to fund. I have not confirmed, so I don't want to spread rumors. So I wondered if a DST was a superior option. Are agency loans available for either? Kevin, you want to take a crack at that?
I have not heard that, so I don't know.
Yeah, I don't think I haven't heard that either. We still do the only 1031s into a syndication that we do are through TICs. And so to the extent people are doing 1031s, it's through TICs. And I think for banks, it's just simpler because they're still just lending on a piece of property to an LLC and then also to an individual. And they're very familiar with tenants and common structures. Kevin, you were about to say something?
And I haven't heard of any problems with that. There's too much syndications have been around forever and banks need to lend money to people. So it might just be the economy in general and not really TICs.
Tim asked to clarify, it's a like-to-like exchange, meaning brick to brick or paper to paper for the DST, or is it just, let me rephrase this. I think, is this just for real estate when you're doing this, Kevin, or could you not really 1031, can you do this DST for business? If I'm selling my business, I want to go buy another business. Is that something that we can do through a DST?
I would have to reread the revenue ruling 86.
It's like a tax bribe. I was gonna say, if you knew, that's more of a, it sounds like a CPA question.
Yeah, but I've got 3 tax attorneys in my office that I can hit up for it. I just don't have that answer right now. Let me, I will
Right.
get that
You look at
answer
that. We'll
and get it
go.
to Mauricio, and Mauricio will get it to you, Tim. I know, I mean, a 1035 exchange, so there's other avenues that the IRS allows. So perhaps company to company. I'll find out.
All right, cool. And then what I'm going to start doing, guys, is last week, for example, we just ran out of time to ask all the questions. So I'm actually going through the chats, and I'll start putting them in the Facebook group and answering them, sort of one by one as sort of individual posts as well. This is, I think, more Kevin. I don't know what your level of expertise is in cost segregation studies, but we had Yona Weiss on last week, and we did a whole cost segregation thing, and he did talk about 1031s and cost segregation. So the question was, does a TST benefit from a multifamily cost segregation tax benefit? And Jonah specifically addressed, they said you can definitely do a cost segregation when you're doing a 1031. So I don't know why, this is more of an IRS thing. I don't know why you wouldn't be able to do it with a DST.
Yeah, I would have to think so. It's all about papering, following their rules. And I don't see why, if it's approved for 1031 exchange, the cost segregation should follow.
Susan, I think you direct messaged me, but you're asking for Kevin's details. If we could share that, and we'll definitely do. I'll put them in the chat. Kevin, real quick before we move on, I want to move on to the estate. This is obviously part of an estate plan, so I want to touch upon that as well. What's the best number? And I'll put it in the chat. What's the best way people can reach you?
858 755 6672.
6672, 858-755-6672, and then maybe email or
is Kevin
Yep.
at tresp.day.com, TRESP as in Peter, day, DAY.com.
Cool. If you've got another DST question, drop it in. And if we've got time, I'll come back around it. But one of the things I wanted to talk to Kevin about as well is that all of this stuff, trusts, LLCs, all these sort of, really, I think of it as asset protection stuff, but it really has to do with your overall estate plan too. And one of my pet peeves is that I think, and I'm sure Kevin will agree with me. Of course, Kevin's got major conflicts of interest on that one, but I don't. I do believe that every single person who's a syndicator or has businesses or anything that should have a sort of a robust estate plan. And I think most people think of an estate plan, Kevin, as a will, right? Or maybe a living trust, but most people just think, oh, I have a will or something or something. Give us sort of the really high level, because I was really impressed. I know you did my stuff, but when you guys do an estate plan, you end up doing like 11 documents. It's not just a will or just a trust. So don't walk us through all 11, but walk us through what an estate plan really is and why everybody should have one.
Yeah. When we talk about estate plans, it's not just a living trust by itself. That's malpractice in our opinion. It's a comprehensive estate plan. And that means everything to deal with your incapacity and your death. So we want the trust itself, which I'll expand on, but you want your powers of attorney for financial matters, your power of attorney for real estate transactions, which is a separate one in more and more states now, your powers of attorney for healthcare. You want to pick the right person to make the right decision, maybe multiple people. If your kids are going to be if let's say your kids are adults and they're going to make the decision, one might be traveling and the other may not be, so you have backups. My son, his own opinion is that he would want to be unplugged, but I have not given him that authority because he would go to his death saying, I killed dad because I approve that. It would just haunt him. He's not the right person to give that authority to. My daughter, I could have given it to her when she was 8 and she would say, fine, if that's what you want, Dad.
What, for some reason, we've been getting a lot of this lately, and I don't think people are dying. Maybe they are dying, and I'm trying to think. But for syndicators, if a syndicator gets a call that one of their LPs passed away, right, without an estate plan, or maybe with an estate plan, what are some of the steps they should take, or what should they be looking for in terms of documentation to prove that, hey, now distributions have to go here, or yes, this is a legitimate will, or no, it's not, and so it's going through probate. Like if I'm a syndicator and I just get an email saying, hey, sorry, John Doe just passed away, please send all the money now to Jane. What should a syndicator be looking for in terms of proof, or how does that process really work if they have an estate plan, if they don't have an estate plan?
Yes. So a living trust, a revocable living trust, avoids probate. That's its real purpose, is so you don't have to pay a lawyer. And in many states, here in California, it's statutory, it's 6% of the estate. And it's not the equity, it's the fair market value. So if you have a bunch of property and you only have 20% equity in all of it, it doesn't matter. The attorney gets paid off of the gross value of the estate, which is, yeah, 6% of $500,000 is way more than what a living trust would cost, much less the larger estates. It's the same 5 forms, whether it's a $200,000 estate or a $15 million estate. But in all cases, a will, if you have a will, you still have a full-blown probate. But even if you have a trust, the part of the 11 documents that are in a comprehensive estate plan includes a will, and also directive to visit, or also guardianship provisions for your children. But the will always has to be lodged with the probate court, even if you're avoiding probate hearing and process case, if you have a living trust. So one, that would be a prove up. Show us the probate bill, to show us that a probate has been opened for Sally Smith. And then also give me the copies of the trust, and they don't have to give you the full copies. They might give you the full copies, but you're actually only entitled to the certificate of trust that shows that the trustee has the legal power to buy, sell, and interact with you. They're the new president. The successor trustee is the new president, to use corporate terms, of this organization, and has the authority to say, make distributions now to this account, and make sure you want to cover your liability. Make sure that you have a copy of that certificate of trust, that they have power, that a probate was opened, that proves that they died, and that the account that you're sending it to is in the exact name of the trust, not being wired over to the supposed. We also have a litigation department, and there's all kinds of, usually family members, but sometimes non-family members, that take advantage of somebody's death and rip the estate off. So you don't want to be the cause of that, because then you get sued by the actual heirs if you're not sending money to the right place.
So if someone has, that's right. But if somebody has a trust, right? If I have a living trust, I'm going to be investing in the syndication via that living trust, right? And so if I die, from a syndicator standpoint, nothing's changed. I'm continuing to make the distribution. All the wires go to the trust. Is that correct?
Right. The trust one is the same trust. It just has a new trustee, because the originators died, and they're bound by the same conditions. They can't say, "Oh, we need money. We want to liquidate," and say, depending on the provisions in the TIC, you don't have that right. You get the income, monthly income, and you have to wait like everybody else for the project to finish.
And so that one's actually not super complicated, because it's still yes, there's a different trustee, but it's almost like if they have a holding company and you're sending distributions to an LLC, you die, it doesn't matter. Maybe the manager changes because now there's new ownership. But what if they don't have a trust, Kevin? What if a syndicator gets an email from Sally that says, hey, my husband John is an investor in your deal. Unfortunately, he passed away. Please send all of your, distributions now to me, or what have you, because I'm really concerned about the liability part of it. What should they be asking? What's the document, or what should they be asking for before they start sending distributions to somebody else other than the original investor, and be confident that they're doing it, that the person is telling me that they have that authority, they have it, is that a probate order or something? What does that look like?
Yeah, so you would want to go through the same thing, look at that the probate has been opened, and then ask for their attorney and interact with the attorney representing that estate of the person that's passed on.
And when you say attorney, it's not necessarily the deceased attorney. Is that the court appointed attorney, or is it the deceased attorney?
Probate attorney, which is probating the deceased's estate.
That you're paying through the probate costs, the 6%. Is that the 6%? Is that that's how he or she gets paid?
Certainly going to be part of it, what they're tracking. But you want to make sure that that depending on the state, is it community property state? Is it not? Let's say if the husband died first and the spouse is saying, send me money, well, maybe he has different heirs because of prior marriage, children kind of thing. So you don't want to be caught in the middle and run it through the probate to make sure that it's official and that you're not the one holding the bag.
Right. Tim asked actually a good question. I know the answer to the first one because I've done it, but do the docs need to be notarized? I know the answer to that is yes, but what if the syndication, or let's just say the syndication, what if it's held in a sort of a tenants in common between a husband and wife, or even maybe just a couple of business partners? How does that work from a probate perspective or from an estate planning perspective?
Yeah. Tenants in common is very old law, so you're in safe ground, but things can happen. And so I would still unless they're actually doing something nefarious, they're going to be happy to provide the probate number and the probate attorney.
Okay. So just in case we haven't scared people enough, why don't we summarize why someone should have an estate plan? Why should they not go through life even as a syndicator, right? What are the cons of not having a full estate plan? Maybe that's the question I should ask. What are the cons of dying without an estate plan? Talk about costs. So that's one, right? Going through you got to go through probate, cost,
and time. Probate's even the most simplest state is going to take a couple of years. With a living trust, you have a notice period where you have to notice whether people are heirs or not, but they're presumed. Let's say you're disinheriting one of your children through a will and the trust, that you still have to, by law, give notice so that they can challenge it. And there's, maybe they have some other documents that say, no, they promised me in exchange for me doing such and such that I was going to get the cabin up in, Lake George. So they have to be noticed, and then they have a period of time to respond. It's usually 120 days. Theoretically, on day 121, you could distribute all the assets. There's usually a lot going on getting appraisals and everything that it takes longer than that. But academically, you could, where for 9 months in probate, a judge does administrative things. They don't even look at if there's a will, much less if there isn't a will. They don't look at anything for 9 months. Everybody has a chance to answer. Then they start looking at administrative things. It takes a long time. If the heirs don't have their own wealth to run things, they might be wealthy, but they don't have liquidity because they're using their funds properly. Then you have to have a court-appointed trustee. So not only is the attorney getting 6% of the estate, some court-appointed trustee is getting paid $200-300 an hour to pay the electricity and pay the mortgages and talk to the investment house and all of that. So it's a very expensive process, and it takes a long time, unnecessarily long time.
My big takeaway for this essentially on the estate planning thing is just as a syndicator, whenever you get that email, because we get emails, at the very least, forward it to your securities attorney first, forward it to some attorney, because the last thing I want you guys to do is just take whoever's emailing you, which is probably a spouse or a father or a mother or something. Obviously, they're grieving, so you got to be sensitive to that. But just be careful. There's a lot of potential exposure for syndicators if they just willy-nilly take their word for it and start redistributing, the distributions or sending K1s to somewhere else. You want to make sure that that's tightened up. So I would probably recommend, I think most of my clients will email that to us and we'll then try and guide them in the right direction. But it's definitely not a DIY project. Kevin, I've already kept you longer than I wanted to, but is there anything I missed or I should have asked on the estate plan? Obviously, estate planning is the reason I've got Kevin on. I'm not an expert in estate planning. I'm not an expert in DSTs. Anything that the community should walk away with from an estate planning perspective, do's, don'ts, pros, cons, top 3 mistakes or whatever?
This is one of my personal things, everything is, if you have minor children, you really need to get your estate planning done, because it includes the guardianship, who's going to take your place as a parent. And the process is very akin, it's before a judge, and a judge is going to take the most expedient way. And if certain, let's say, siblings or friends that you would naturally choose to be the surrogate parents for your children, don't step up and say, I want them, I'd be love to take them. The court is going to gavel down on the one person that did come forward and say, I'll take them. Or there's 5 of them that come up and they say, oh, we love those kids. We love Kevin and Susan. We definitely want to take their kids. The one that has the extra rooms is going to win out. And they're not necessarily philosophically and lifestyle the person that you want, so that's critically important for their whole life trajectory, for you to plan who would be the surrogate parent for them. And it shouldn't be based on, it's a loving environment. Who cares about the extra rooms? Kids with a loving environment can live in pup tents in the back, although the court would not be happy with that. But
I know the other one that you spend a lot of time with, which is always a difficult one too, is just the finances, right? So many of us have some sort of a life insurance policy. So if something were to happen to us, there's just a big chunk of cash that hopefully will take care of your kids, at least get them through education, food or whatever. But, are they going to get a lump sum? What's the default, by the way, Kevin? If I've got a life insurance policy that goes to my kids and it's $3 million, if I don't have anything, does this just the entire $3 million just get transferred to whoever their new guardian is, or is there a default where it gets paid out over time? Or because that was a big struggle for me.
Yeah, so that's why we'll usually use dedicated ILITs, irrevocable life insurance trusts. They're very narrowly drafted, irrevocable trusts, so that the gift is the $1,500 a year, not the face value of $2 million that are ultimately going to a child. So it gets it out of the estate. But you can put provisions in a trust, conditions of inheritance. But even if you're not going to do a dedicated ILIT, irrevocable life insurance trust, if you have a living trust, we make the living trust the beneficiary, not the child, because the child, as soon as they're 18, they're entitled to control of that and get it all at one lump sum, where the trust can put provisions of, roof over their head, medical conditions, help with college, give them even a living stipend, but they're not going to get the other 1.5 million until certain age requirements, typically.
I know you can get creative. I mean, we were talking, and we still might change ours. Maybe you want to invest that money for them. You don't want to give them the lump sum. You want to give them the cash flow, or maybe you want them to put money with certain syndicators and get them provisions. So all of that stuff needs to be written somewhere. And if it's not going to be in your living trust document or wherever, it's just going to. The default is by statute, right? I mean, if I live in California, I don't have a will, I don't have a trust. The state of California is going to dictate who gets my money, when, and how, and all that stuff, right?
Yeah, it's family tree. It's down to your children. If none, then it goes up to parents. If they predecessed you, then to your siblings. And it's all lump sum as long as they're adults.
Well, my friend, let me read back here. Get a hold of Kevin. Appreciate his time. 858-755-6672 or Kevin at Trestday, TRESPDAY.com. Got a lot of nice comments here at the end, Kevin, about peeling back the curtain. So really, really appreciate your time. And I will see you this weekend, my friend. I'm sure we'll grab a beer, grab dinner or something. And for everybody else, next week, I'm doing the tokenization of real estate. I'm actually speaking in Austin on the Michael's blockchain and real estate. And so we'll do a little live on sort of real estate tokenization 101 and how it applies to syndicators. And that might be of interest to some of you. So until then, thanks everyone for joining us. And we'll see you next week at same time and same back channel. Thanks, everyone. Thanks, Kevin. Appreciate you.